Hi, everyone. Thank you so much for joining our quarterly compliance webinar, providing insights to employers on the latest in industry legislation, regulatory updates, and noteworthy compliance topics. This webinar is brought to you by Orange Tree Employment Screening and will be hosted by Heidi Seaton, Orange Tree's VP of Legal and Compliance. Heidi has been in the background screening industry for 18 years and has been at Orange Tree for 10. If you have any questions afterwards, you can email Heidi at hseaton, that's HSEATON, @OTES.com, or text them to 952-237-7471. The slides from the presentation and a recording of the webinar will be available afterwards as well. Thank you all for joining us.
Thank you, Suzanne. So good afternoon, everyone, and welcome. For those of you who've been attending this series each quarter, thanks for coming back. And for those of you that are new, here's our agenda. Slide advance. Okay. We'll talk first about what we're seeing, legislation and case law developments happening at the state and local level. So we'll talk about ban the box, including providing updates on those that we talked about at our session in March, as well as what's passed and pending since then. We also have had some developments regarding local privacy legislation and Social Security use legislation, and then we'll spend some time talking about state drug testing law developments, both legislation and case law, and we're especially focused on medical marijuana legislation this session, as state legislatures are wrapping up their spring sessions. On the federal side, we'll revisit some of the FCRA case law and a proposed FCRA amendment of note. And then we talked about introduced federal privacy legislation, federal EVerify legislation, and federal ban the box legislation in March. So I wanted to provide an update. But as you can imagine, with politics being what they are currently in Washington, it'll be a short one. And then we'll wrap it up. So as Suzanne mentioned, for those of you that don't know me, my name is Heidi Seaton. I'm VP of Legal and Compliance here at Orange Tree. I've been in background screening in one role or another, actually for 19 years now, the last 9 years in compliance. And I love talking about this stuff, so I can't wait to get started. But I do need to just stop on this slide for a moment and remind everybody that I'm not your lawyer. This is not legal advice. And I always recommend that you seek the advice of your own legal counsel for all matters of employment law and policy. So thanks for that brief stop there. Moving into the state and local law topics. We're just going to jump in with ban the box at the state level. And a reminder for those of you, if it's been a while, this is that effort that started a number of years ago with just removing the criminal history question from the employment application, and then has subsequently really broadened to include, in some cases, restricting when employers can do background checks, perhaps requiring additional steps or obligations around adverse action. And it's really evolved into now what's becoming known as fair chance legislation. By our count, we've got 35 states that have adopted some sort of statewide laws or policies that regulate public employment in some ways. And then of those 12 states, California, Connecticut, Hawaii, Illinois, Massachusetts, Minnesota, New Jersey, New Mexico, Oregon, Rhode Island, Vermont, and Washington have also created mandates for private employers. So important distinction there. There's a lot more legislation of government employers themselves, agencies, counties, states, than private employers, but that is also happening. And then at the local level, the District of Columbia and 33 cities by our count and counties now also extend those fair chance policies or ban the box policies to public employers, government contractors, and then 18 of those also have obligations for private employers. So lots of action happening here. Maine is our first new addition for this quarter's update. You can see it's state legislation, so it's at the state level. It affects the entire state. It was signed into law on April 5th. It goes into effect on August 23rd. it's actually 90 days from the end of their legislative session. So assuming they end on time, it should be right around August 23rd. This does apply. This is one of those state statutes that applies to state employment. So it doesn't apply to private employers, but basically it prohibits questions on the employment application form. And it also actually limits its state employment, but it doesn't apply to political subdivisions, which is a little different. So it doesn't apply to counties or municipalities. It only applies to state employees. And then there's an exception for positions in school administration, and then also an exception for other positions where criminal records would make an individual ineligible based on the nature of the position and some other state statute that applies. This is one I've got update next to it because we were watching this at our last session in March. It did pass and was signed into law in April. Effective date for that one is coming right up, June 14th. And it does affect private employers, and it defines in the statute a private employer as an employer with four or more employees. So there's very few exceptions to employers not affected. It prohibits asking about criminal history on any application. Interesting language there in the statute. I'm not sure how many applications employers are doing in New Mexico, but it does say any. And then it does allow for consideration of criminal history information after review of the applicant's application and upon discussion of employment with the applicant. So sometime after the employment application, after review of the application, and once you've discussed employment with the applicant. So that will be an interesting one for New Mexico employers to implement, I'm guessing. Third addition here at the state level is North Dakota. They passed their legislation and signed it into law March 13th. Expected effective date there is August 1st, so here at the end of, towards the late summer. Again, this affects public employers, so here it's state, cities, counties, agencies, so much more broad. And it prohibits employers from inquiring about or considering criminal history until the applicant is selected for an interview. So again, just pushing that question to later in the hiring screening process. It does not apply to Department of Corrections and Rehabilitation, and has broad exceptions for any public employer that's required by law to check or consider criminal history of an applicant by statute or regulation. Another newcomer to state ban the box. This is just pending signature by the governor, which is expected. So legislation passed. If it signs, it would affect all employers, so not just private or public employers. And it's got a September 1 effective date. Employers would be prohibited from stating in an advertisement or application that a person with a criminal history can't apply to the position. And they're also prohibited from inquiring into or requiring disclosure on an initial application. Take this question off your application if you have one, if you're Colorado. And then it has, again, some of the usual exceptions where if there's here in this case actually federal, state, or local law or regulation that prohibits employing a person with a specific criminal history. And then also if the position participates in a federal, state, or local government program that encourages employment of people with criminal histories. In those cases, there's an exception and employers may ask the criminal history question. I included this one on here because we did talk about this in the March session, so I wanted to give an update. The measure did not pass in Kansas, and the state legislature adjourned, so I don't expect to see it pass this year. They're out now until January. But recall that Nebraska already had a 2018 executive order prohibiting public, that is state employers, from including that question about criminal history on the employment application. So the the bill did not pass, but there is already that executive order in place, so keep that in mind. Another state with ban the box legislation that, again, in March when we talked about, looked like it would pass, but it didn't. It was a broad bill. It was intended to affect all employers, not just public employers. That would have prohibited asking about criminal history on the initial application, but then allowed it once there's an interview, but not allowing background check until a conditional offer was in place. So that one, again, legislation was introduced. It passed in the House, but not the General Assembly, and then they adjourned. So I expect to see, we'll have that one back next year. But again, here, recall, Maryland does already have ban the box legislation that regulates public state employers, where this one was intended to regulate private employers or affect private employers. So interesting development there. Also, don't forget, if you're one of those private employers, there are also local ban the box ordinances in Baltimore, Montgomery County, and Prince George's County. So some already broad impact there. Virginia, another one we talked about in March, so I wanted to give an update. The measure didn't pass. The state legislature did adjourn, so I don't expect to see it pass this year. Another one here, Virginia has an executive order from 2015 that prohibited state employers from including the question on the employment application. So this would have just ratified that into statute, and that did not pass. Honestly, the way the ban the box movement is going, anything that didn't pass this year, I'm expecting to see again next year, and we'll talk about it some more then. Moving into then local ban the box action. So again, as I mentioned in the sort of this first slide on this topic, lots of state law action here, but we're also seeing a fair amount of local jurisdictions, so cities and counties, city councils that are creating ordinances around it. South Fulton, Georgia is a local city that passed and city council passed an ordinance. It does apply to only the city, so city hiring and city hiring or hiring by city contractors. But it requires those employers that it applies to delay asking about criminal history until an interview or until the city determines the applicant to be otherwise qualified. So if they don't have an interview, it then just has to be delayed until there's a decision about qualification. Another local ban the box ordinance approved by Pine Bluff City Council in Arkansas, effective May 31st here, so coming up. Also applies to city departments, so city employees basically, and it directs the removal of the question about prior felony convictions from the city's job application. Does not restrict city employers from actually doing a criminal background check, just removes the question from the application. So that's ban the box. We're going to move now into related, what I think of as related, local and jurisdictional legislation and ordinance passing that we're seeing. And this is related to salary history bans. As we discussed last time, this is becoming a trend. By our count, there are now 15 states and 13 local ordinances on the topic, and they're somewhat similar. Mostly, in general, the idea here is to not ask applicants about their salary history as part of the negotiation or the background screening process. Maine here passed state level legislation in April, effective date coming up in September. This legislation says that an employer cannot make inquiries about past compensation until after an offer, and the offer has to include compensation terms. Also employer can't make inquiries of the applicant or the applicant's current or former employer regarding compensation or past salary. And then there's an exception. It says it doesn't apply when federal or state law requires disclosure of verification of salary history. So something going on there in Maine. In North Carolina, we had an executive order signed by the governor in April with immediate effect. So this is going to apply because it was just an executive order to state government agencies that are under the governor's office's purview. And it says that these agencies may not request salary history from applicants. They have to remove that question from their state employment application. And also that they may not make use of any previously collected salary history information. And then where salary history information is public record, they have to have policies, procedures in place to ensure that the information isn't used in a discriminatory manner. Moving into the local level, so again, sort of similar to ban the box, we see this movement of or wave of legislation at the state level, and then a follow-up wave at cities and counties. Same thing happening here with salary history bans. Cincinnati, Ohio passed a city ordinance in March. That's got an effective date a year out, so 2020. But it does affect all employers, public and private, within the city, and it prohibits employers from making inquiries about salary history to an applicant or the applicant's current or former employers. And it also prohibits search of publicly available information related to salary history. Kansas City, Missouri, continuing the trend. The city council there approved an ordinance on the topic in May. Effective date here in October. And it applies, again, to employers in the city, so not of the city, so employers that are located in Kansas City. And it prohibits asking applicants about salary history, screening candidates based on a current or previous wage. So that means, not screening someone out or in, I guess, based on the current or previous wage. And then it also prohibits using that salary history as a deciding factor in hiring. New topic because new trend, right? This is one I don't expect to see go away. We'll talk about this a little bit more too when we touch on privacy legislation being introduced at the federal level. But in the absence of federal legislation, we are definitely seeing state privacy legislation being introduced. In this case, in all cases so far, other than California last year, we're not seeing them pass yet, but just in case employers were struggling with their obligations around state-by-state ban the box, salary history, breach law notification, we're now seeing a number of states trying to, in the absence of that national preempting law, enact their own privacy legislation. Generally, we saw this legislation taking the European Union approach or the California approach in being sort of broad, expansive. For instance, in Washington, it had provisions for that would allow individuals to know what information data companies were gathering about them. It would give them a mechanism to correct inaccurate data and request some sorts of data be able to be deleted, and would have restricted some facial recognition programs by companies and law enforcement, in some cases requiring consent. So interesting approach that we're seeing in Washington. We also saw bills introduced in Texas, Massachusetts, New York. Nothing passing yet. But we do expect to see this legislation reintroduced next year. I don't really think anything's going to pass this year, but gosh knows, given my track record on Ban the Box from March, don't count on me. But certainly anything that doesn't pass and more states we expect to see introduced next year. And at that point, we'll also have a couple of months of effectiveness, the California privacy statute will go into effect here at the beginning of next year. So we'll have a couple of months of that under our belt. So it'll be interesting to see how that legislation will be drafted or if it will be affected by how that California rollout goes. Speaking of privacy legislation, on a related note, we have seen a few states enact legislation now related to the use of Social Security numbers. Maine here passed House Paper Legislative Document 305 or 229-305, restricting employers' request of Social Security numbers from prospective employees. Basically, it said not allowed to be requested on the employment application or during the application process, and then happily threw in an exception for some drug testing and for pre-employment background screening. So potentially a significant impact on Maine employers there on that limitation of use. Although I think for the most part, employers generally were not collecting Social Security numbers from applicants and were only doing that post-offer and generally also as part of the background screening process. But just something for employers to be thinking about there in Maine. Note this, by the way, this is the third new state statute coming out of Maine that we've talked about just in this session. They've been very active in consumer and employee protection laws. Indiana recently enacted an interesting statute. It's not directly related to employer use, but as you'll see, it could have an impact on some of the services that employers do as part of their background screening program. It's passed in May 1st of this year, so kind of fresh off the presses, and it requires a credit bureau that uses a Social Security number as a factor in determining whether a file matches the identity of the subject of the credit inquiry. How's that for convoluted language? To ensure that the name and at least one additional identifier of the subject matches the name and the same identifier in the file. So basically it's saying, hey, credit bureaus, you can't give a credit report based just on receiving a Social Security number. You also have to match on a name and potentially on an address or some other additional identifier before you return that subject's credit report. We're still working with our credit bureau partners to determine what that's going to look like for us. We already require more than a Social Security number when we're doing credit requests, and so I think the real question will be that Social Security number trace product, but we'll have communications out to our Indiana clients about that in the near future as the credit bureaus work out what they're going to do and how they're going to change if they are. So again, a little change in topic here, but it's a good place, I think, to just talk about a specific state issue. We had a recent opinion coming out of Wisconsin that's, I think, just a good reminder about why employers background screen and what exactly they're screening for. Wisconsin employers, as they're deciding whether to hire an applicant with a criminal background check, often find themselves between a rock and a hard place. If they fail to take reasonable care in screening applicants, they could face a negligent hiring claim. But if they screen too stringently, then they could face allegations that they violated the Wisconsin Fair Employment Act, which prohibits discrimination against an applicant with a conviction record that doesn't substantially relate to the job. In this case that we're just going to talk about really quick here, Palmer v. Cree, the employer manufactured and still sells lighting products, and they looked to hire an employee to perform and design and sales duties. So that employee would have worked at a manufacturing facility with about 1,100 employees. It included manufacturing, storage, conferences, cubicle spaces. This candidate applied for a job and had 2 positive interviews, and then the company did a criminal background check. And it showed that in 2012, he'd been convicted of a felony strangulation and suffocation, a 4th-degree misdemeanor sexual assault, misdemeanor damage to property, and misdemeanor battery. So Although the background check didn't reveal it, he also had been convicted of battery in 2001. He discussed his convictions then with the company, and they said and he told the employer that they were connected to a domestic situation. So the company had a matrix that they used that sort of listed out convictions, and certain crimes automatically disqualified a candidate from being hired. And these convictions disqualified based on their matrix. And so he was told he wouldn't be considered further. He filed a complaint alleging that the company had violated the Wisconsin Fair Employment Act prohibition against rejecting a candidate based on his conviction record unless the conviction record substantially relates to the job in question. And it went to an administrative law judge. So this ALJ found in favor of the company and said the convictions substantially relate to the job. The judge said it was significant that the position involved completely unsupervised one-on-one work with customers, and determined that the employer's large female population was problematic because Palmer if he developed a relationship with a coworker and it ended badly, he could exhibit the same type of behaviors that led to his conviction. He appealed, and so that appeal goes to the Wisconsin Labor and Industry Review Commission. So that's a special commission that reviews labor disputes. And they said the LERC, which I just love that acronym, reversed. They said no, according to the commission, for a substantial relationship between the job and the conviction to exist, there has to be a realistic possibility of recidivism in the new job, and that this requires analyzing whether the tendencies and character traits that led to a conviction are likely to reappear on the job. They held that the convictions were not substantially related to the job Palmer sought, and that just because the job required unsupervised conduct with customers at their homes didn't suggest that he would engage in the same type of contact that led to the convictions. And then finally, that the mere fact that women would be present at work was not enough to find a substantial relationship. According to LERC, there was nothing about the work atmosphere that would trigger Palmer to repeat the crimes for which he had been convicted. Shocking, I think, to a lot of employers. Wisconsin employers maybe not so much, right, because this isn't the first sort of similar opinion that we've had come out of Wisconsin. They are really serious about documenting, finding how the particular records are substantially related to the particular job. So it's just a reminder, especially for Wisconsin employers, that even the most serious crimes may not be considered job-related. And so an individualized assessment could have helped the employer consider the circumstances surrounding the crime and the nature of the job and all the other relevant facts. So again, it's not clear to me here, by the way, whether if we had better facts here, if the employer had done an individualized assessment, whether the LARC might have come out different. But very interesting case, so I wanted to share it with you guys, especially our friends in our neighboring state of Wisconsin. Back to updates from March. In March, we had talked about the sort of anomalous. We hadn't seen a state advancing or trying to enact really seriously EVerify legislation in a number of years, and we saw it happen in Iowa. We thought this one had momentum because of the kidnapping and murder of Molly Tibbetts in that state earlier in the year. But it did not pass. Legislature adjourned here in May, and so that might come back again next year or in a later session, but for now, did not pass. So moving on to state and local drug testing law developments. So I'm just looking at the time and realizing I probably got to speed up a little bit. New Mexico amended their existing medical marijuana law. That was in April. did a couple of things. It expanded the range of medical conditions that are covered by the law. It prohibited employers from taking adverse employment action against an applicant or an employee, so applicant or employee, so that's pre-employment or post-employment testing, based on conduct allowed under the medical marijuana law. And by the way, prescription and prescribed marijuana is allowed by the law. So interesting development in New Mexico. Doesn't protect employees who use or are impaired by medical marijuana while working on the premises or during hours of employment. So it does have some protections for employers built into it. Oklahoma also had a medical marijuana law, and so this was sort of a unifying bill to add some additional meat to the law. Effective date here is September. And this one says employers cannot penalize an applicant or employee solely on the basis of their status of a medical marijuana license. So by penalize, I mean make any sort of adverse decision. Can't refuse to hire, discipline, discharge, or otherwise penalize is the full language of the statute. And then in the event of a positive test, again, may not penalize an applicant or employee solely on the basis of a positive drug test result unless they don't have a license to use medical marijuana, unless they actually possessed or consumed or used or were under the influence while at the place of employment or during the fulfillment of employment obligations, or if the position is one involving safety-sensitive jobs. Safety-sensitive, by the way, is defined in their state statute, so it's not the federal DOT safety-sensitive definition that you're thinking of, but an interesting development there. New York City, going to the local level, again, we see this trend of legislation happening at the state level, and if it doesn't happen at the state level, and sometimes even when it does, local ordinances being enacted as well. New York City actually, City Council passed this bill in April, and it became law on May 10th because it wasn't vetoed. The effective date there is a year out, so by May 10th of 2020, we'll have to, New York City employers will need to be thinking about removing marijuana from their pre-employment drug testing panel. So it says employers and others, right, labor organizations, employment agencies, agents, may not require a prospective employee to submit to testing for the presence of tetrahydrocannabinols or marijuana in such prospective employee system as a condition of employment. So pretty significant legislation there coming out of New York City, but we do have some time on that one. So what have all these state legislations meant for employers, especially as it relates to medical marijuana? Employers now have the difficult task of reconciling their anti-drug policies with those state statutes authorizing marijuana use for medical purposes. Add an additional layer of complexity, there's also the growing number of states that also are legalizing marijuana for recreational use. So perhaps the most common issue we're seeing in case law is whether employers have to accommodate an employee's use of medical marijuana for a disability. Because marijuana continues to be an illegal drug under federal law, the Americans with Disabilities Act doesn't require employers to accommodate employees' off-duty use of medical marijuana, even when condoned under state law. Several states have legalized medical marijuana, but their statutes may or may not protect off-duty use. So that's really the question for most employers. In those states that do protect off-duty use, a positive drug test alone won't warrant disciplinary action. Employers will have to provide concrete proof an employee's intoxication while they're at work. Some states are also requiring that employers reasonably accommodate employees who use marijuana for medical purposes, such as giving additional time off for absences, And then most states still provide exceptions for those employees in safety-sensitive positions. This recent opinion, Bravado, out of Massachusetts High Court, highlights the trend towards protecting workers who partake in medical marijuana outside of the workplace and outside of work hours. In Bravado, the court held that an employer had to provide a reasonable accommodation to an employee for off-duty use of medical marijuana, even though the employer had a zero-tolerance drug testing or drug policy. So the facts here of the case, this employee accepted a salesperson position that was contingent upon passing a post-offer drug test. After accepting it, the employee informed her employer that she used medical marijuana to treat her Crohn's disease. And then when the drug test came back positive, the employee was fired for violation of the company's drug testing policy. So here where the Massachusetts High Court allowed the employee's reasonable accommodation claim to proceed under state law, the court held that the employer had to engage in an interactive accommodation process and that an exception to the company's anti-drug policy to allow the off-duty use of marijuana for medical purposes could constitute a reasonable accommodation. So employers in these states where there's protections for off-duty use, be pretty careful about that. Connecticut and Delaware also have similarly interpreted their state laws. So spend some time on that if you're in one of those states. Another case worthy of note here, a New Jersey appellate court held that a disabled employee can sue a former employer under the New Jersey law against discrimination for alleged discrimination based on the employee's use of medical marijuana. So basically in this case, they said that the New Jersey Compassionate Use of Medical Marijuana Act doesn't prohibit employment discrimination based on medical marijuana use. It held instead that it doesn't immunize an employer from obligations already imposed otherwise, which is to not discriminate. So a very narrow holding, well, I should say a narrow interpretation, I think. And honestly, this is a tough one for employers because it ignores a 2018 federal court decision, also in New Jersey. We discussed this one in a session last year, Cotto. That court had held that neither the New Jersey law against discrimination nor the Medical Marijuana Act compels an employer to waive its requirements for employees to pass drug tests, even when those drug tests include testing for marijuana. That court said it was significant that the Medical Marijuana Act didn't provide any employment protections for medical marijuana users and predicted that the New Jersey judiciary would conclude that the law against discrimination doesn't require an employer to accommodate employees' use of medical marijuana. Not exactly what we saw in this case, right? So that court's prediction apparently wrong, although it's far from clear. That this wild case is still, this is an appeal, so it's been remanded and it's working its way up again. So lots of things for especially multi-state employers doing drug testing to be thinking about. All right, I've got 5 minutes to get through federal stuff here, so I might go a little bit long, but I'll try not to go the whole hour. I know we talked about this case last in March, and I had it on here to review again, so I'll go through it really quickly. But this was that case coming out of the Ninth Circuit. It includes California. The FCRA disclosure allegedly also included state disclosure language. And the employer tried to have the case dismissed, won on summary judgment at the district level. The Ninth Circuit reversed and said, nope, go back, look at the evidence again. They said this is that holding about including state law disclosures in the federal disclosure violates the Fair Credit Reporting Act's standalone requirement. It rejected the employer's argument that, including state law notices with the federal law notice would actually be likely to inform and not confuse. And also, it made the distinction between conspicuous and clear. So in this case, it said, yep, the disclosure was conspicuous. It was clear that it was a disclosure, but the actual content of the disclosure was not clear because the addition of the state law disclosures, they said, and some grammar issues made it unclear. So also implied California law because the ICRAA, the California Consumer Reporting Act, also has a standalone requirement. So this is an important case. And I just quick review there because then on the heels of that, right after in April, we had what I think is slightly better news for employers, although for a limited time. The California Court of Appeals affirmed summary judgment in this case for an employer in an action alleging class-wide violations, again, of those hyper-technical Fair Credit Reporting Act allegations. So the plaintiff's class action here alleged two violations. One, that its background check disclosures didn't comply with the FCRA standalone disclosure requirement, and two, that it rejected certain applicants based on information in their consumer reports without following the required pre-adverse action, FCRA pre-adverse action process. The employer moved for summary judgment. The trial court granted in this case. The plaintiffs appealed, and in this case now the Court of Appeal affirmed the trial court's decision. So it came down on the side of the employer. It said the employer's disclosure didn't constitute a willful violation of the standalone disclosure requirement because until the previous case, until Gilberg, there was no definitive guidance on the topic. So that's very interesting. And then it also said, no, the pre-adverse action process in this case was actually pretty straightforward, and it met the requirements. So certainly a victory for employers, but do know the law here is developing, and employers should continue to be mindful of their obligations under state law, and especially how those intersect with those FCRA technical or hyper-technical requirements. Interesting. We don't see this all that often, but we did see introduced legislation that would amend the Fair Credit Reporting Act. It would basically delay reporting of medical debt in credit reports, and then also remove medical debt or require removal of medical debt once it's paid off or settled. We'll watch this one, but it's all Democrats that introduced legislation. I'm not sure that it's got a ton of support, but it might. It's not terribly controversial. Again, though, given the level of partisanship on the Hill, well, maybe we'll know more in July or August. Ban the box or fair chance legislation at the federal level. We talked about this in March, so I wanted to give an update. The update is there's no update. Both houses introduced the legislation, and so far really the only progress has been that it made it through the House Oversight Committee, and there it's pretty much stalled since late March. I don't foresee this passing, certainly not before the summer break, but it could come back up in the fall. EVerify, so also an update from last time. This is legislation that it was broad. It would have required all employers in the U.S. to begin using EVerify within a year. It's still pending. It hasn't gone anywhere. It got introduced by Senator Grassley, and it's just not moving. So the bills were introduced both in the House and Senate, both referred to committee, and it doesn't look likely to pass. Again, certainly not in this session. I think it's unlikely this year. And national privacy legislation bill being considered. Yeah, we talked about this last session too. There was a lot of talk earlier in the spring about creating some nationwide privacy legislation similar, maybe not terribly similar to, but having the effect of or similar to the EU's general data privacy regulation. I'm not seeing anything coalesce around one or two bills or a few bills that are likely to be able to work together across the two houses. So we're just a few weeks now until the summer recess, so I think it's unlikely that we'll see these bills gain any momentum to actually pass this year. We'll keep tracking it though. So I'm just like 1 minute over. I think that's pretty good for me. If you need more or if more information is of interest to you, we've got a link here on the slides to our blog, to our website, to some videos, services that's also on our website. My email address is there over on the right-hand side. If you want to email me a question, a follow-up question on anything I covered today, I will be happy to at least field the question and provide some sort of response. You can also send a text to Jeff, our VP of Sales and Marketing. His cell phone number is there. And if you have any questions, please do reach out. For those of you that are Orange Tree clients, your client success partners are also a great resource if you have follow-up questions. So everyone, thanks so much, and have a great Wednesday, and we'll talk to you next quarter. Thanks.
Thank you, Heidi. That was all very interesting and very helpful and full of important things for employers to consider. Like Heidi mentioned, if you have any questions, you can email her directly at hseaton@otes.com, or you can text us at 952-237-7471. I do see some questions in the chat. We'll be sure to follow up with you with answers to those questions. And just a reminder that the slides from the presentation and the recording of the webinar will be available afterwards as well. Thank you so much for joining, and we look forward to connecting further.